26-year-old Ralph Yarl went to the house on 115th Street instead of 115th Terrace, which was only a block away. And he did so in order to pick up his younger brothers. After ringing that doorbell, Andrew Lester shot Yarl in the head and arm. Yarl is now recovering from his injuries at home. 84-year-old Lester, who you see here, is white and has been arrested and charged with 2 felonies, including felony assault in the first degree.
Is an A felony. It carries with it a range of punishment of up to life. In count 2, the defendant is charged with armed criminal action. This is an unclassified felony. It carries with it a range of punishment between 3 to 15 years.
John Passarino joins us now live. He's a criminal defense attorney and a former prosecutor. John, thank you so much for being with us today.
You're welcome. Thank you.
So, John, one of the laws that we continue to hear mentioned is Missouri's Stand Your Ground law. This law was the law used in Florida in the Trayvon Martin case. What is Stand Your Ground, and could it be used here?
Yes, Stand Your Ground means different things in different jurisdictions. As far as Stand Your Ground in Missouri, there's no specific statute that has that language attached to it. However, what it really means is, and what is in the statute is, that someone does not have a duty to retreat when faced with a threat of death or serious physical injury.
All right, and the prosecutor in this case, Zachary Thompson, the Clay County prosecutor, had mentioned a racial component, but he didn't really go into specifics. He did so during the press conference. How do you believe race is going to play a factor here, and potentially on what legal grounds?
Sure. Race always plays a factor in the criminal justice system. As far as his stating, the prosecutor stating that there was a racial component here, I am not sure what he was referring to. I reviewed the complaint and the probable cause statement. There's no evidence that this crime was motivated by race. Obviously, the victim is black and the defendant is white. And what the defendant said during his interrogation was that he opened the door and he shot, and that he saw a black male outside of his door. But as far as any kind of evidence saying that he shot the person because the person was black, there's no evidence of that in this case at this time.
But he has been charged, and I want to go through some of those charges and what they mean for Arthur Lester, among them felony first-degree assault. Why was Lester not charged with attempted murder?
In Missouri, assault in the first degree is a Class A felony. It's more serious and has more punishment than attempted murder, which is a B felony. The punishment for a B felony is 5 to 15 years. The punishment for an A felony, one of the 7 deadly sins that we refer to it, is 10 to 30 years or life in prison. And the thing about the A felony is it carries with it an 85% amount of time that must be spent in prison prior to probation or parole. So it's a much more serious offense, and it carries a greater range of punishment than does attempted murder. The second charge, which is the armed criminal action charge, or commonly referred to as ACA, carries a range of punishment of 3 flat years in prison to 15 years, provided that it's a first-time offender. And I believe that the defendant in this case is a first-time offender. However, the important thing about this charge is it must be served consecutively to any sentence that he were to receive in count 1. So if he got the minimum in count 1 of 10 years and he got the minimum in count 2 of 3 years, he would have to serve 13 years in prison prior to being released on probation or parole.
And this is a case that has already gotten a great deal of attention from the media. This morning, I believe Yarl's parents were making the rounds with the morning talk shows. The Yarl family has gotten a phone call from President Biden. How does this impact a potential trial?
It can impact it, keeping in mind that any trial of on this case will probably not take place for another, 10 months to a year to 14 months. Many of the jurors prospective jurors will not have even heard of this case. And certainly when you pick a jury in a case like this, you question them about their biases or any preconceived beliefs that they may have about this particular case. The other thing that's noteworthy about this case is that rather than being in Jackson County, which is a more central city of Kansas City, This jurisdiction where he's charged is in Clay County, which is more of a suburban area. So the component of the jury, or excuse me, the jury will be comprised of significantly less people of color than you would anticipate receiving if it had happened in the central city.
I wanted to also ask you, John, and sorry to interrupt you, about
That's okay.
the suspect's age in this case. Arthur Lester is 84 years old. Will this play into what happens next? Could this play into this case at all, his age?
Absolutely. The jury, if it gets that far, is going to have to make a decision about whether he acted reasonably. And he's allowed to use that much force to defend himself and or his property in Missouri as he believes the force that's coming with him either to kill him or to cause serious physical injury to him. So this incident was alleged to have taken place at approximately 10 p.m. He told the police he was in bed. He grabbed his revolver. He went to the front door. He opened the front door for some unknown reason. And then he saw a 6-foot black male standing there. He told him that he was afraid for his life and that he fired the shot, 2 shots almost immediately. And that's how it happened. Ultimately, the jury's going to have to decide if they believe that fits under our self-defense statute. And the other thing that's important to remember here is that the prosecutor has the burden to not only prove that the defendant committed assault in the first degree, in other words, he intended to cause death or serious physical injury to this individual, but the prosecutor must prove beyond a reasonable doubt to the jury that the defendant did not act in lawful self-defense. So there's a couple of different burdens for the prosecutor to overcome in order to obtain a conviction in this case.
And we are running out of time, John, but how do you believe this is all going to play out?
You know, it's a close call. This is kind of like the first inning of a baseball game. As I tell all my clients, there's a long way to go. Right now, when there is a close call in cases like this, you tend to think that it's going to be a defendant's verdict. You just don't know. The unknown are the physical evidence, the DNA that exists on that door, the fingerprint that may exist on that door. And to me, the one key piece of evidence is, did the young man, did he touch that door and try to open it and enter the man's home, or did he not? And that will be a factual determination that the jury will have to make.
Right, which is why stand your ground could potentially play a factor here. John Paserno is a criminal defense attorney and former prosecutor. John, thank you so much for stopping by. We do appreciate it.
Okay, never a prosecutor, but thank you. I appreciate it.
Oh, you weren't? Okay.
I was a public defender all the way.
Got it. All right. Well, I appreciate the correction. Thank you so much, John.